Hello, this is Matt on the Moon Lambo channel. Do you remember Dr. Albert Metz? This is the individual who was hired by the SEC as an expert witness, paid $600 an hour to create a 100-plus page report that allegedly proves that XRP, if not for the efforts of Ripple, would never have gone above 2 cents. Completely bogus report. I've torn the whole thing to shreds. I've talked about it in multiple videos. Well, as it turns out, that's not the only expert witness that the SEC has on deck. They also have one Patrick Doody. Yes, you heard me right. Patrick Doody. D-O-O-D-Y. Try and withhold the chuckles. This is the worst name that I've ever heard in my entire life. And mind you, I actually met, in real life, Dr. Richard Head. And I'm not saying that to be funny. I met Dr. Dickhead. Richard Head. I kid you not. I'm keeping that guy's business card forever. He is not my doctor. But I met him, and it's hilarious. This name's worse. Patrick Doody. Oh, this poor guy. So this individual, he wrote up a report. Don't have access to it. But Attorney John Deaton found out, thanks to Ripple's attorneys, that Patrick Doody wrote up something. He's got some sort of report. And undoubtedly, it's going to have a bunch of terrible nonsense to say about XRP. He was also cited in the SEC versus Telegram case. This Patrick Doody's comment. I kind of want to laugh every time I say it. Patrick Doody. His comments were highly consequential in the Telegram case as well. So Attorney John Deaton put together a letter requesting that Judge TORRES be granted access to Mr. Doody's report. The SEC doesn't want to have it. And also be able to ask for permission to file a response regarding that report. So I'm going to share with you the specifics, so you may hear this in the hands. This is the 5-page letter from Attorney John Deaton, which I have to tell you, it's really well written. So not just the so it's not just the arguments. The arguments are very solid, unquestionably. You'd expect that from Attorney John Deaton. You'd also expect it to be written professionally. And my gosh, everything about this, as far as I'm concerned, he just completely knocked it out of the park. So what I did here is I highlighted the parts that I found most pertinent. I'm not going to read literally the whole thing to you, but I'm going to explain it as I understand it and read you some parts. And I made a couple notes along the way just to make sure that I didn't miss anything that I thought to be of crucial importance to share with you all out there listening. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so this just happened this evening, by the way. This was first reported, at least I first came across it from Eleanor Turret. May not have been the first individual to report this, but Eleanor Turret, you may remember, she is a journalist at Fox Business Network who has been covering the SEC versus Ripple case. And from the way that she writes, although I'd say that, you know, she's pretty unbiased, she seems to recognize a lot of the absurdity that's coming from the SEC. And so she tweeted out the following just a few hours ago. Breaking. Attorney John Deaton has filed a motion letter asking the judge in the SEC versus Ripple case to let him write a brief on behalf of the 67,300 XRP holders who have been hurt by the lawsuit. The move comes following recent testimony from an expert SEC witness who gave a report on what information reasonable XRP holders were relying on when they bought the token. Deaton says he bets this witness gave testimony without interviewing a single XRP holder. More to come. Yeah, I'd be willing to bet. So this Mr. Doody, Doody. I love this. We can all be 5 years old when you have a name like that. Like, come on. Dr. Richard Head. I'm sorry, guys. Just give me a second here. I'll compose myself. I promise. But look at this. Look what we know at this point. Okay. So this expert was hired by the SEC to give information about what reasonable XRP holders were relying on when they bought the token. And you know, if it's somebody on the side of the SEC, it's going to be a bunch of nonsense, jibber jabber, and hoo-ha. And the SEC, although this report was not initially confidential, they don't want to see it. They don't want anyone to see it, apparently. Except for Ripple, of course. Ripple allowed to see it. Here's what Attorney John Deaton had to say. He wrote, I encourage everyone to read the 4-page letter motion. It is packed with information, including how XRP holders took the time to try and make sure that the actual truth sees the inside of the courtroom. And so here's the letter right here. And the fifth, so it's 5 pages, although the 5th page is just a signature line, basically, here. But it reads as follows, and so I'll try and remember to scroll through as I'm covering various parts of this, but it reads as follows. Dear Judge Torres, Your Honor previously granted Amici status to 6 individual XRP holders. Amici respectfully request leave to file an amicus brief regarding the opinions of plaintiff's expert, Patrick B. Duty. And just to be clear here, when he's saying Amici requests, is referencing himself and the 67,000 plus XRP holders out there. That's Amici, the friends of the court. Anyway, Attorney Deaton continues. Dalbert concerns related to Mr. Duty's opinions represent the precise nature of the difficult issues envisioned by the court when it granted Amici status and held the following, and this is a quote, Amici will provide the court with a meaningful perspective and will help ensure complete and plenary presentation of difficult issues so that the court may reach a proper decision. And so again, when Dalbert concerns are referenced here, you're talking about an expert witness whose either credentials, it could be credentials and or methodology for submitting whatever information, whatever report they put out are questionable. That's when you issue a Dalbert challenge. That's what was being referenced there. Anyway, Attorney Deaton continues. Counsel for Amici recently became aware of Mr. Duty's report regarding the conduct of individual XRP holders such as Amici. Because again, pause and note, Amici, that's us. That's the holders, the 67,000 plus XRP holders. And so here you have Mr. Duty talking about the individual XRP holders, the conduct of them. Many of you listening out there, no doubt. He's talking about you, actually. Did he talk to you? Did he talk to any of you? I would love to. If the answer is yes, please let me know. I'll make a video about that. That would be really interesting. I'm guessing the answer is no. Anyway, John continues. Candidly, there may not exist a more singular and relevant issue necessitating Amici's meaningful participation than the legal issue surrounding the opinions and testimony of Mr. Duty. Mr. Duty. All right, let me get to the next. I'm just going to chuckle the whole time we're going through this video. Like, that's just how it's going to be, folks. That's just how it's going to be. There's a one line up in here I wanted to highlight. Yeah, here we go. So check this out. Amici became aware of Mr. Duty's opinions after receiving a reply letter from defense counsel. So this means that Ripple's lawyers told Attorney Deaton about this existing. That's the reason that we know that this report exists. And then there was also this portion, which, let me read this, which I'm highlighting on your screen right now. The SEC did not designate, and this, by the way, this comes from Ripple's attorneys. They wrote the following. The SEC did not designate Mr. Duty's report, dated October 4th, 2021, as confidential, and thus there is no restriction on the party sharing it with Amici, and no court approval is required. And so, end quote. So right there, that's Ripple's attorneys saying that Attorney Deaton, they can have access to Duty's report because there was nothing indicating that it was confidential. Now I scroll a little bit further though, the asshats at the SEC ain't have none of that because they're asshats at the SEC. Take a look at this. Attorney Deaton wrote the following. On May 10th, 2022, undersigned counsel, so that would be Attorney Deaton, sent a letter to all counsel inquiring whether Amici would receive Mr. Duty's report. On May 11th, 2022, counsel for the SEC, so that would be the SEC asshat attorneys, counsel for the SEC sent an email to defense counsel, so that's Ripple's attorneys, copying Amici, so that would be Deaton, indicating that the SEC was in fact, quote, designating all expert reports submitted on behalf of the SEC as confidential. So there you go. Suddenly it becomes confidential after all this happens. Well, go figure. Any of you surprised? I'll tell you, these petulant children at the SEC, anything they can do to make things that much worse for everybody else participating in the case, they're just going to do it. Petulant children here. They're completely terrible creatures. My gosh. Like, why did nature make such creatures? I don't like, how did this occur in nature? It's crazy. These people are just awful. Grinds my gears, folks. It grinds my gears. All right, now starting right here, let me read some further. So this is more from Attorney John Deaton. And this is basically, so this is Attorney John Deaton asking the judge for a copy of Duty's report along with others. So it reads as follows. Thus, Amici respectfully requests leave to submit a brief related to the opinions of Patrick B. Duty. Additionally, Amici respectfully requests the court grant access to Mr. Duty's report and deposition testimony solely related to his opinions regarding XRP holders and users who acquired XRP in the secondary market. Amici intends to limit participation to matters solely related to XRP holders who have acquired XRP in the secondary market. So I'll just pause to note again. Like Amici is here. So again, John's here. The purpose is to provide a unique perspective outside of what the defendant, Ripple, could possibly provide right here. And so noting here, as he stated very clearly, that it's just going to limit the participation solely, and this is a quote, solely related to XRP holders who have acquired XRP in the secondary market. That's exactly the point of John Deaton participating in this case on behalf of over 67,000 XRP holders. Getting to the core of it. The judge should support that. That makes perfect logical sense right there. And then he also wrote the following. Amici will offer no position regarding Mr. Duty's opinions, if any, related to Ripple investors, customers, partners, or any purchasers of XRP who acquired XRP directly from Ripple or its executives. So let's pause and note, that's good. And again, I don't have a legal background I'm pretending to, but just as a layperson reading this, I'm sitting there thinking, yes, exactly. You're emphasizing, John, he's doing an excellent job, emphasizing to the judge that we're making a request, but it's absolutely within the confines of what the court has already made clear should be done in regards to participation from Attorney Deaton. Perfectly clear. So I think he's hitting it out of the park here. And then he wrote, but when considering opinions related to the users or purchasers of XRP in the secondary market independent of the defendants, it is quite difficult to imagine a more relevant and pertinent issue justifying Amici's participation. According to defense counsel, so that again, that's Ripple's attorneys, Mr. Duty, quote, has offered views on the conduct of reasonable XRP purchasers, end quote. So again, right there, I'm wondering, he's offered his views on the conduct of many of you listening. You're the XRP purchasers. Did he talk to any of you? I'm gonna guess no, but he sure has some opinions, and the SEC's paying him money. So there you go. Attorney Deaton continues. Hence, Mr. Duty's opinions, if accepted by the court, could prove critical in the court's ultimate analysis of whether XRP acquired in the secondary market constitutes an investment contract under Howey. So, folks, this is highly consequential. And let me just point this out before going further. There was this. This is an article from Crypto Briefing, and they're talking about Mr. Duty and his participation regarding the SEC versus Telegram case. So take a look at this. According to Mr. Duty's expert opinion, it was reasonable for a purchaser to buy grams with the expectation of profit derived from the work of Telegram in developing Ton's blockchain systems. That is Telegram. Doubling down on his claim, Mr. Duty said the following. This is a quote from Mr. Duty. It was unlikely that a reasonable purchaser would acquire grams in order to purchase goods and services because, among other reasons, there were no identifiable uses for grams at the time, end quote. So folks, that sounds like the type of argument that the SEC is making about how there's no utility for XRP, even though there is utility for XRP. But consider it further. You know the SEC is also going after a library. Well, look at what the SEC wrote in the library case. It's on your screen right now. Here's a snippet from the SEC. The possibility of using LBC, that's Library Credits Cryptocurrency, the possibility of using LBC on the library network for video-related purposes, which purchasers could do during most of the offering, but not at the beginning when library promised LBC to testers, does not negate the expectation of profits by a reasonable LBC purchaser. So think about this. Just because something might go up in price relative to the United States dollar, that makes it a security. Look, here's what Library had to say about that, because my gosh, that's overreaching and scary. Library wrote the following on Twitter. It's hard to overstate how broad and devastating this claim from the SEC is. If purchasing for usage is insufficient to make something not a security, then practically everything is a security. And not just every cryptocurrency, but Beanie Babies, baseball cards, houses, etc. End quote. That's what Library said. And that's right. If that's the problem, that it might be worth more and people are purchasing it, at least one reason is because they think it's going to be worth more in the future, bam, it's a security. That's not just every crypto on the planet. That's everything. Not literally, but I mean, you might think that certain things are going to go down in value, like, you know, a car or something like that. Although with inflation recently, that's not so much been the case. But you get the cut of my jib here. So the reason I took the time to highlight all this is because Mr. Duty was quoted, I think, like 7 times in the Telegram case by the SEC, in a document towards the end, if I'm recalling properly. And that's consequential. And this guy's saying crap about XRP, which isn't going to be good or grounded in truth and reality, right? I think that's a reasonable assumption. Kind of concerning, is it not? I think the answer is yes. And so moving further down, where am I now? I think I just lost my spot. I guess I was down here. Yes, I apologize, folks. Let me just make sure. Yeah, here. Yep, this is it. Okay, we're good. Mr. Deaton also wrote the following. Although Telegram involved an initial coin offering with very dissimilar facts, Mr. Duty's report was cited 7 times in the court's decision granting summary judgment in favor of the SEC. There you go. Well, how about that? 7 times. So yeah, my memory was correct on that. Duty's opinions, if accepted by the court, could have a devastating impact on the present and future interests of Amici and the public at large. Amici strongly believe they will provide the court with a meaningful perspective unique from defendants. There you go. So this is actually potentially rather highly consequential. You know, if Amici, John Deaton and our 67,000 plus XRP crew, if we're not here for this, then what the hell are we here for? So the judge, by and large, I think very reasonable. Not happy with everything that happens, but you wouldn't expect that to be the case, so that's okay. I respect the judges in the case, both Netburn and Torres. I think they're going to find that this makes sense. Anyway, Attorney Deaton continues. Amici and the public's interest in this case cannot be overstated because the SEC's position on XRP is not limited in scope to the defendant's offer and sale of XRP. The SEC has broadly asserted that today's XRP, including XRP traded in the secondary market, independent of Ripple, also represent investment contracts with Ripple. In the SEC's own words, quote, the XRP traded even in the secondary market is the embodiment of those facts, circumstances, promises, and expectations, and today represents that investment contract. End quote. So folks, in a nutshell, XRP, by the nature of existing, is a security. That's effectively the argument. Completely bogus, but that's what the SEC has the coconuts to claim, let's say. Attorney Deaton continues. The SEC is endeavoring to brand all XRP, including XRP traded today in the secondary market, independent of the defendants, as investment contracts with Ripple. The promises and expectations referenced in the SEC's sweeping statement above include sales of XRP sold by XRP holders, including Amici, who acquired XRP in the secondary market with no connection to Ripple. The court itself has recognized and commented on the SEC's extraordinary claim that all XRP constitute securities. Exactly. Which I've highlighted a number of times over the, whatever it's been, a year, whatever it's been. I can't remember exactly when that exact assertion was made. It's probably been a little over a year. Either way, I've mentioned that a number of times, and you're probably aware of it. It's a big claim because, and I'll tell you, if the SEC wins on this, what the hell isn't a security? Everything's a security. Your mom, brother, and sister, they're all securities. Everybody. Your dog, you got a cat? Securities. Attorney Deaton continues. It appears Mr. Duty is being offered in an effort to support the SEC's far-reaching and all-inclusive theory that XRP itself is a security per se. Amici are the reasonable users, holders, developers, and acquirers that Mr. Duty opines about. Mr. Duty's opinions and the litigation surrounding those opinions are precisely the type of difficult legal issues Your Honor envisioned when the court determined Amici's participation desirable. Yeah, exactly. Well worded, Attorney Deaton. So it's the reason we're here. Judge, please allow this. That's what I'm saying. Like, I think it would make sense. And then he also stated, Amici respectfully requests the court grant access to Mr. Duty's report and deposition testimony. And so that's all that I highlighted for this. It's worth reading the whole thing if you got some time to do this. But I think those were the most crucial of points, just from in my humble opinion right here. So absolutely well crafted. Looking forward to seeing what the judge has to say about this. Expecting something positive. Never know for sure. But my gosh, what could Mr. Duty have to say? I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.